Who owns intellectual property created by employees in a company? In recent news, a hot topic has emerged in the world of business law. Who actually owns intellectual property created by employees in a company? This question is becoming increasingly relevant as more people engage in remote work and creative projects. If you are working on a new invention or software while employed, you may be wondering about your rights. Typically, intellectual property created by employees during their employment belongs to the employer. This principle is known as work for hire. It means that any inventions, designs, or software developed by an employee as part of their job duties are owned by the company. Most employment agreements specify that the company retains ownership of all intellectual property created during work hours or using company resources. This includes software, inventions, and other creative outputs. However, employees can negotiate exceptions in their contracts. For instance, they may retain rights to work created before their employment or outside their job responsibilities. It is essential for these exceptions to be clearly stated in the contract to avoid confusion later. To prevent disputes, companies often draft clear agreements that detail ownership, usage rights, and confidentiality. These agreements define who can use, modify, or license the intellectual property and under what conditions. Protecting intellectual property through registration and non-disclosure agreements further strengthens legal ownership. This helps companies enforce their rights against unauthorized use or theft. Commercial law supports these arrangements by providing frameworks for transactions involving intellectual property. This includes licensing or sales, ensuring companies can manage and protect their assets effectively. In summary, unless otherwise agreed upon, intellectual property created by employees in the course of their employment is owned by the employer. Employment contracts and relevant legal frameworks back this principle. Clear contractual terms and protective measures are vital to prevent ownership disputes and safeguard company assets. As the landscape of work continues to evolve, understanding these rights is more important than ever for both employers and employees.